Good morning, everybody. I am Margaret Henkel. I chair the Post Commission. Let me call our 28th public meeting to order at this time. I will ask for a roll call of the commissioners in attendance. Commissioner Bluestone.
Here.
Commissioner Calderon.
Present.
Commissioner Ellison.
Good morning, present.
Commissioner Kajirosian.
Good morning, present.
Commissioner Luma.
Good morning, present.
Commissioner West.
Good morning, present.
Commissioner Wynn.
Good morning, present.
And therefore, we have a quorum in attendance. Commissioner Sherry is unable to be present today. Let me ask now for a motion to approve the minutes of the meeting of June 30th and July 12th.
So moved.
Is there a second to that motion?
I'll second.
Any discussion? If not, let me call for a vote, please. Commissioner Bluestone,
Approve.
Commissioner Calderon,
I approve.
Mr. Ellison,
Proof.
Commissioner Kajirosian,
Approve.
Luma,
Approved.
Commissioner West,
Approved.
Commissioner Wynn.
Approved.
I also approve. They are unanimously approved. I want to thank Attorney Lee for having drafted those minutes. Let me now move on, please, to the Executive Director report. Please.
Thank you, Madam Chair, and good morning, Commissioners. I'll share my screen in a couple of minutes to, like I've done in the past, go over a PowerPoint presentation that summarizes some of the activities that we have had in the past few weeks since our last meeting. In short, the team has been very busy with the certifications, as I've been reporting in the past, as well as the technology solutions, and of course now the growing division of standards, trying to look at some of the exceptions in some of these certifications. So with that, let me share my screen real quick. Just bear with me. Can everybody see this?
Yes.
Okay. What I want to do right from the beginning is to give you a comparison on some of the numbers relative to the pre-certification effort compared to what I reported last June 30th. Commissioners might remember, we also had a July 12th meeting, but side by side, some of the numbers that we have seen in the web tool relative to the certification, pre-certification effort. We have had about 1,200 additional submissions, and they have landed, I guess, in different categories. There's about 1,100 more people certified, and those notifications have been going out as we review those submissions. The number of conditionally certified individuals has grown slightly in those additional submissions. However, the individuals that are pending further review has gone down a little bit because we are, as we speak, doing the review that our regulations provide for, and the most relevant one are, for example, individuals whose chief does not attest to, but that's on the basis of something that has been adjudicated before, and then a review of those that criteria against that submission is enabling us to move them to a separate category, mostly certified, but in some cases conditionally certified. The instances of not certified has grown slightly, and we'll continue to review all those cases carefully and notify them accordingly. The number of agencies that have submitted that ask for an extension is down from 13 initially to about 5 or 4, and I'll speak to that in a couple of minutes in the next slides. And you can see that that's the reason why these numbers of pending submission has gone down. Because in June 30th, there was only an estimate. We didn't have a solid number of how many people were going to be included in the rosters of individuals, of agencies that were submitting at a later time. That's what we are calling it, an estimate. We are now estimating that with the pending submission agencies at around 1,000 individuals, we're going to end up at approximately 8,806 individuals that we're going to be, analyzing that fall within the A through H category. I'll continue. I put this slide together a day or two ago, and since then we've already seen New Bedford come in. So we stand at currently 3 agencies only, with the following numbers that they have supplied to us of pending submission. So we this is where we come up with 1,000 or so individuals, and they're mostly in the Boston PD, who commissioners might remember, they asked for a second extension, and that extension expires August 15. So we have sent, the certification team has sent additional reminders to these now 3 agencies that we're expecting those submissions again by August 15. I have here a reminder that as of our last meeting, there were 13 agencies pending submissions, and they all have complied, and the team has been reviewing all of those submissions. I have some numbers that are important to, I think, to highlight. There's about from the previous slide, there's about 835 conditionally certified individuals, and these are the most common. This is how the breakdown of instances falls that the team is reviewing or is requiring somebody, the individual whose certification is conditioned. This is what they need to remedy. There's very few people with no high school diploma, and they have, commissioners might remember, until 2024, I'm sorry, to get this done. There's 402 individuals with no basic training, and these mostly are people in the reserve category who are either attending or should have attended a bridge academy. A subset of that are people that have passed an exam as part of that training. There's the requirement of in-service training, an annual in-service training that individuals are required to conduct, and that stands currently at 306 individuals. And I should note that per MPTC regulations, they have until September 30th to conduct the in-service, the fiscal year in-service training. So we're keeping a close eye as to these, and we'll manage how those updates come into our portal. There's a very small number who have never had a background check, and they still need to have that conducted. 175 people, also in the scheme of things, it's a small number that don't currently that are not current with their CPR certification, and 187 people or individuals who did not conduct an oral interview. All of these technical exceptions, as we like to call them, have to be dealt with in some timing, and the most immediate one is September 30th, as our regulations and the statute provides. I would note that the total number of instances is different from the total number of officers conditionally certified, which is why I don't have a total here. Because of course, there's individuals with more than one exception. And that breaks down in the following way. A third of those 835 people have one condition. There's 41% with two conditions, and a few with three or four or more conditions, as is stipulated in the screen. I have other certification metrics. Of course, these aren't final because we will have more submissions, notably from Boston, in the coming days. But we also checked against the requirement of the statute that everybody be under the age of 21 and nobody falls in that category. We're checking that no one have been convicted of a felony, and that is the case as per the submissions. Commissioners might remember that when it comes to the physical and psychological evaluation, we are not, this is not a pass-fail question at this point. We will be doing that, we will be addressing that element of the statute later, but we still collected information on whether they had ever had a physical test or a psychological evaluation done, and they break down in the following way. 37 individuals with no physical test and 793 individuals without having had a psychological evaluation in the past. Some departments we know anecdotally instituted the psychological evaluation process, maybe some 10 years ago or so. And so this probably applies to the more senior officers when it comes to these exceptions. Again, something that is not a pass-fail, but something that we still felt necessary to report and measure as we consider how we're going to implement some of these requirements in the statute. Additionally, just some other activities that that I have been reporting that also continue. Given the amount of data that we collected, there's still a little bit of cleanup that we need to do when it comes to name and date of birth. This is something that allows us to identify the officer. And as we are seeing and corroborating data with training data, for example, with the MPTC, we're seeing some discrepancies. And that's just the way they entered information. Maybe somebody's named Jake, and they put into our system Jacob, and that all of those things, the data has to be reconciled. The same thing with the dates of birth. That is currently the name and date of birth and agency are three data fields that allow us to identify the officer. But we're considering the possibility that we might have to capture Social Security numbers to ensure that this ambiguation does not continue. But again, we're thinking about that as we continue to develop the technology solutions. And I should say, this is not a big amount, a large amount of instances, but because it's so critical that we have the right individual, I notice that that there's still a little bit of that reconciliation going on. As additional submissions have come in, we process them, the certification team process them, and they are notifying on a rolling basis. We've updated the website recently to add additional detail as to especially what the conditional certification category entails, and how individuals are required and agencies are going to be required to submit evidence that they have completed those exceptions. And that's a work in progress, but there's new content in the website that explains that process. I should also mention that as we exchange information with agencies on individuals, the portal that we built, that the technology people helped us build, is documenting all of these changes to the status, which is very critical. If there is correspondence, additional submissions, a second spreadsheet, etc., all of that can be tied to what they call the ticket of the agency or the individual. And all of that process all of that communication is documented and tied to that individual, which is critical in terms of data management and workflow processing. And that's working fairly well. We're also still developing solutions, a solution for managing and sending notifications in a more efficient manner, although we are still sending them, and those status changes, and that is ongoing. Some of the aspects of this solution will be, again, to receive the evidence of those people that are receive and process evidence of people who are in the conditionally certified category. I mentioned this aspect last time around, and I have a little bit more detail to offer, and that is that in the coming days, we will be sending correction letters to people that, to very few individuals who we either certified or conditionally certified, but whose category should have been a different one. The most important categories or subcategories in this aspect are individuals who may have answered yes to the question about basic training or the Breach Academy, but the answer should have been no. We have the algorithm that we built to issue as many certification letters and notifications as possible relied on the answers that the agencies submitted to us. But in some instances, we are verifying that information. And we have done so with the training records of the NPTC, particularly when it comes to those that should have attended and should have finished the Breach Academy. Because some of these submissions were also before or by June 15, there was still time to finish, or still time to, in some cases, sadly, be dismissed or not finish the Breach Academy. And some of these instances is what brings us in this category, in which we will be sending correction letters to a few individuals who have not met these criteria and should have not been certified. There is also one instance of one individual who is listed in the NDI, the National Decertification Index, and our statute requires that people that are listed in that index not be certified. That answer should have been no, and the answer was yes. And again, we'll be sending a correction letter to that effect. Let me also mention that what we're doing with that information is run all of the names and dates of birth against that National Decertification Index. Unfortunately, that has to be done one at a time. We're not doing it. We're not inputting that information manually. We have a server, a computer server, helping us do that at nights, and that is why some of the information, some of this exception, came out a little later than the original letter was sent to the agency and that individual. We'll continue to do those corroborating efforts with training, NDI, and other areas as the submissions continue to flow into our portal. Let me move on to a couple of other activities going on that affect us Commissioners might be aware that the budget at the state level is ongoing, and the particular sections that pertain to post. There's information about that in a memo that's included in the packet. But for the purposes of this report, I wanted to highlight that our funding, which we expected to be $5 million, was in fact the case. But there's language here that requires us that prior to no later than March 10 of 2023, we shall submit a report to the House and Senate that includes the caseload of 2023, fiscal year 2023, complaints received by the Commission, and certain patterns of police conduct that have been identified by the Commission, which again is, and the number of police officers suspended and the reasons for those suspensions. The first three, of course, is information that I have been reporting and that we're building, and we are now continued to capture in both the submissions that we are getting to the interim and the soon to be developed permanent solutions, and we will be in a position to report well before that date and continue to report publicly as we continue our work. I'll remind commissioners that the statute requires additional reporting of post, including an annual report, and we have begun work. We will begin work on that annual report as we speak. The statute is not, neither the statute or this outside section is specific as to whether we should do an annual report on a fiscal year or a calendar year, except what I just read which is the current caseload for fiscal year 2023. We need to report to the House and Senate before March of that year. And we can choose to do a cutoff as of June 30th, which is the fiscal year end of last year, fiscal year end 2022, or calendar year end of 2022. What we are envisioning is that we will then have a cutoff and then take some time to make sure to put together the report. And that usually, my expectation is that 3 months perhaps after that cutoff date, we will be in a position to send that report. And we have leeway to choose whether we report on a fiscal year basis or on a calendar year basis. And there's benefits, given this particular year, there's benefits and there's some trade-offs between doing one or the other. If we cut off as of June 30th, we will be mostly reporting on what was due to post as of that time. And we could always include additional information, since then as something to look forward to. Or if we choose to report on a calendar year basis, we will then be in a position at the end of this calendar year to report a lot of what has transpired as a result of our analysis and certification that was due by June 30th of this year. In other words, the people that are certified, conditionally certified, et cetera, et cetera. So I don't have a strong recommendation either way, but at this juncture, but I wanted to highlight that we could also do a partial report this time around and then catch up to either a calendar or an annual basis, a calendar basis or a fiscal year basis in the next year. But the point is that we are working with, we have the tools and necessary to aggregate data, and are also, at the rest of this meeting, we'll begin talking about what we make publicly available. And we, as we continue to think about these reports that are due, both as part of the requirements in the statute and as part of the budget that just passed. Actually, let me also mention in the packet there is language that has been highlighted, that there's a couple of agencies that now will be part of post under post jurisdiction, notably the Animal Rescue League and the MSPCA, the Massachusetts Society for the Prevention of Cruelty of Animals. We'll be coming back to you, commissioners, with a recommendation as to how we address what the legislature seems to have passed relative to these new agencies in the coming meeting. And just by way of administrative update, we are in the cusp of signing a contract with a professional services vendor. That is the technology solution, that's the platform that's called Salesforce. And this is what I've been referring to as the permanent solution. We will be beginning with the big priority of providing a platform and a workflow for the Division of Standards to aggregate complaints that have been flowing into a general mailbox and to match them to disciplinary records and have a case management process for the Division of Standards. That's very much the priority because we have been so focused in the last few months to building the interim solution on the JIRA portal, and that is working fairly well, but we continue to build on that solution. The EOTS team, the Technology Services Division of the Commonwealth, people who have been very helpful, will continue to work on having that recertification process strengthened as we speak. So we have a couple of parallel tracks, but they eventually need to come together because there's a fair amount of information that needs to flow from one division to the other, and that will continue to build a solution. There's also the very important need to capture, manage a lot of information that affects eventually all the individuals that we deal with, and that is notably contact information, making sure that we have the right individual, as I mentioned earlier, whether it's by social security number or other unique identifying number, including something that the MPTC uses, but notably as well changes in employment status. When people go from one agency to another, maybe leave of absence, go on injury leave, all of those things are going to be important for us to track as we continue to manage all the information that we are managing. And let me just finish my report with welcoming 2 new staff members since our last meeting. We have a second Deputy General Counsel. I saw her on the screen earlier, Pauline Nguyen. I hope I'm not mispronouncing her name. And our Human Resources Manager, Janine Hopkins, that have been with us for a couple of weeks, but this is their first public meeting as a staff member. So I will pause there, commissioners, and take, of course, any questions that you may have.
I think Commissioner Ellison has a question, Enrique.
Oh, yes, sorry.
Good morning, Enrique. Thank you for your report. Bear with me because I have a few questions, if you don't mind. One, just on the high school diploma issue, I was just curious as, it's required to have either high school or GED, just trying to figure out how someone has police powers and doesn't have the minimum standard.
That's right. The statute does require that. We asked that question, as I mentioned, Commissioner, and we have identified that in 4 instances, they do not have that. According to the plan that we put together and brought before you, they have until the end of fiscal year 2024, I believe June 2024, to complete that. So they're conditionally certified on the condition that they complete either a high school or a GED. The idea behind 2024 is that you might remember that we would not give individuals according to their last name a different amount of time to complete something like this. And so if there's other individuals, I through Z, without this requirement, everybody will have the same amount of time or deadline to complete this requirement. But it's a requirement of the statute, and that needs to be completed.
Thank you. And my second question is just to familiarize myself and maybe the other commissioners, the agencies that ask for extensions and have not completed it, how are their members being carried?
So they're conditionally certified as per our regulations. They, it's not fault of their own, and we have the power to extend for good cause those submissions. So they don't lose. Nobody's losing their status or standing as a police officer. And the condition is that the agencies submit that information, and we can process them accordingly. And again, that status may change based on our review, but that's where they stand currently.
And my final question to you, sir, have the individuals and their departments that are not being certified been notified and aware of the appeal process?
Yes, they're the ones that the 15 individuals that I mentioned that are not certified have had a letter to that effect. And there's a remedy process, a review process, as you suggested, Commissioner. And we have begun to get some of these notifications and letters from either the individual or their lawyer, et cetera, as to whether they want to review and whatnot. And that is very much part of what's going to keep us busy in the next few months. Another reason that we're growing the Division of Standards, because those communications and careful analysis is going to need to be done in accordance with our regulations. So that's process ongoing, Commissioner.
And so their respective agencies are aware of their status as well?
That's correct.
Okay, thank you. Thank you.
Any other questions from any of the commissioners? I don't think I see any indication of that. Enrique, let me, on behalf of the commissioners, thank you for the thoroughness of your report. Let me thank all the members of the staff who have participated in the work that has led to the report. I continue to say, and I know I speak for all of the commissioners when I say that we are in awe of all the work that has been done to collect this information and to do it in timely fashion. I think with that, let me move on to the next item on the agenda, which is the proposed regulation on dissemination of information. I turn now to our general counsel, Ravitz, with regard to that issue.
Thank you. I will seek to share my screen. Okay. If I could just take one moment here. Okay. This is a draft set of regulations regarding the development of databases and the dissemination of information to the public. And it's intended to capture a number of different areas. At this time, we are not anticipating asking the commission to take a vote on adopting these regulations for promulgation. Rather, we are introducing them to generate discussion from both the commission and people outside the commission, and to continue working on them and presenting them again at a future meeting. I will just go over them generally. As discussed last time, Chapter 6E of the general laws, the commission's governing statute, reflects a balancing between disclosure of certain information regarding officers and protection of more sensitive information. And this is shown in its requiring the commission to develop 4 different databases. One that need not be public, with a list of specific forms of officer information, a long list, and then another public database regarding officers as to which the forms of information are not specified by the legislature, and that needs to be developed pursuant to regulations that must account for officer health and safety. So you see the legislature giving the commission more latitude there and calling for it to account for officer health and safety. Then a third database that need not be public with a list of various forms of disciplinary information regarding officers. And then a fourth database that does need to be public with fewer forms of disciplinary information. So again, giving the commission more latitude. Then turning to the public records laws and related laws generally that govern all agencies, they too reflect a balancing, including a general principle that agency records are public, but then with numerous exceptions. So under the definition of the term public records in the general laws, there are 21 exceptions, and one of them incorporates other statutes that provide for confidentiality. And as I said last time, the Secretary of the Commonwealth's office a few years ago collected a list of 66 examples of those statutes, and there are more out there. And some of those statutes require the withholding of information, sometimes with serious consequences for disclosure. And the remainder of the exemptions allow for withholding, but don't necessarily require it. So these regulations are intended to include a similar balancing to what is seen in Chapter 6E and the public records and other laws. They're intended to address several interrelated areas in one place, to give commission decisions, whatever it ultimately decides, greater weight, because once regulations are promulgated, generally speaking, they have the force of law, and to better inform the public of the rationale and the authority for commission decisions by identifying various sources that either provide allowances for commission actions or restrict commission actions, and also to provide a resource for commission personnel so that when we look to what our obligations are, we can look to a list that will identify other areas of the law that should be consulted before we take action. And so more specifically, turning to the content, they are intended to satisfy the requirement that the commission must promulgate regulations regarding a public database of officer information, again, taking into account officer health and safety, to provide for that database to be combined with the other public database regarding disciplinary information that has to include certain specific types of information. Also to implement certain general provisions regarding agency record-keeping systems. These are provisions that apply to all agencies, and to make those provisions applicable to all four databases, to provide guidelines for responding to public records requests, and to implement certain other provisions regarding public records and related matters. So for example, there are provisions that either say that an agency can take a certain action or that an agency must promulgate a certain policy. And these are intended to respond to those provisions. Moving down to section 8.04, it generally requires agencies to notify officers when they're providing information about them to the commission. And I say generally because there's an exception in there if it would compromise an ongoing investigation or the security of any person or entity. But that in part gives officers some advance notice that information about them might be publicized and gives them an opportunity to seek to correct any inaccurate information. Moving on to section 805, that's the main section concerning the database. It provides for a database that is compliant with various requirements, both in Chapter 6E and in other sources of law. And it's intended to reflect the balancing that I mentioned, the balancing found in Chapter 6E, found in the public records law, and in other sources of law. The first subsection, subsection 4, that I'll be highlighting, provides that certain information must be included. Some of that is already required by statute or regulation to be included. Other types of information are forms of major decisions or major information collected by the commission concerning individual officers. And also the database should provide for ways for people to compile or aggregate various types of information. If, for example, they're looking for all the records regarding officers in a certain agency. The next major subsection, subsection 5, would identify information that cannot be included because there is some statute or regulation that makes that information non-disclosable already. And lots of times, as I say, with consequences, there could even be civil or criminal liability, as I discussed last time. And this section is intended to identify all those things, which you might ask, why would we need to identify all of them if they're found in existing law already? It's to provide a reference for commission personnel, again, when we undertake to build the database or to respond to a public records request, because this is later incorporated into those provisions. This provides something to look at to remind us of our obligations under other sources of law, and also to make clear to the public why certain information is being omitted. Then in subsection 6, there's essentially a second tier of information that's also prohibited, where it either could adversely impact officer health or safety. Again, that's something that the statute requires us to consider, or that where the commission is allowed to withhold it under some source of authority, or the commission may be required to withhold it, but it's not stated as explicitly as it is in that first tier of sources. And the question might be raised, if there's certain information that we can withhold, but we don't have to, why should we withhold it as a general rule? And as I discussed last time, one reason is because the provisions that allow for certain information to be withheld are based on sound policy determinations. They protect, for example, ongoing investigations or information that could compromise security of places and people. And because if we make a mistake and we conclude that information can be disclosed and we're wrong, and in fact, it can't be disclosed, then we could be subject to consequences. Again, there could even be civil or criminal liability if we make a misstep. So there is a benefit to being safe when it comes to that category of information. The next subsection, subsection 7, provides guidelines as to whether a matter regarding certification or a disciplinary matter is ongoing. And that's important because certain public records exemptions call for us to consider whether a matter is ongoing, and that is determinative in part of whether information can be withheld. And then finally, within that section 805 is a subsection that allows latitude for anything not addressed above and gives the commissioners or the executive director discretion to decide whether to include or not include certain things. Moving on to section 8.06, that governs databases generally, and essentially it provides for our systems to be compliant with existing legal requirements. So the first few subsections really just restate things or implement things that are already found in other sources of law. But finally, subsection 5 of section 806 gives an employee the opportunity to exercise the right to correct inaccurate information in personnel records. There's a statute that gives each employee, not just public employees, the ability to correct and expunge information in a personnel record that's inaccurate. But in our situation, what if there is such inaccurate information and then it's transferred to us and then we make it public? The employee effectively will have lost that right, or at least it will not be as effective. So this subsection is designed to account for that and to give an employee the ability to exercise that right, and essentially calls for us to hold off and allow for that process to happen. Section 8.07 moves on from the database to records requests. I use the term records request as opposed to public records request because sometimes what is requested in such a request is not actually a public record, but the requester might not realize that. So this section incorporates existing rules of law that state that records access officers can decline telephone requests, which I think promotes clarity by and prevents disputes about exactly what was requested. and an existing requirement in an agreement that we have with the MPTC for us to refer something to them if it's requesting data that's all theirs. It also provides for coordination with agencies where we may have received similar requests from the same requester. Moving on to section 8.08, this is intended to reflect, again, the balancing that is found in the public records law. So like the public records law, it provides a general rule of disclosure, but then it borrows from those categories that I mentioned above. As to information that's listed above, where some source already bars disclosure, it reflects the fact that that information is non-disclosable. As to that second tier that I mentioned, it generally bars disclosure, but it does provide some exceptions. And again, why even withhold information in that category? Why consider withholding it? As a general rule, two of the reasons I mentioned above, that the provisions allowing for withholding are based on sound policy determinations, and the fact that if we make a misstep, a miscalculation, there could be consequences, but also because the legislature in Chapter 6E showed us a plan, showed us an intent to direct the public to databases that the commission would design and giving the commission latitude to decide what to include in it, and that the commission should balance certain factors. And for that to be essentially the first source for the public to consult. So it takes that into account as well in deciding what to provide or not to provide in responding to public records requests, provided that the law allows it. And it also takes into account practical considerations that I identified last time. The fact that sometimes providing information and having to redact it can be very burdensome and be very costly for the requester. And it incorporates an existing rule of law that an agency can refer requesters to information on websites when it's available there. Section 809 concerns privileged information, provides that only the commissioners can waive a privilege held by the commission, and that if the privilege is held by someone else, we should give them notice and an opportunity to assert it. Section 810 concerns fees. It too incorporates certain existing rules that allow an agency to ask a requester's purpose if we're deciding whether to waive fees. And it provides that even though the law allows us to waive fees, particularly where it would be in the public interest to do so, if the requester is seeking information that is substantially similar to that is already found on the public database and that they can access there, and we give them the opportunity to access that, and they still want to go forward with the public records request, and we're still required to compile and provide all the information, then we're going to assess the maximum fee that we're allowed to do so under the law. So it gives an incentive for people to use the database as the legislature seemed to intend. It also relieves the requester of having to pay the fee until they agree to do so, and relieves us of having to provide information or review records until we receive the fee. And finally, section 811 concerns compulsory legal process. These regulations on the whole, as you've seen, are not intended to provide a comprehensive way of dealing with compulsory legal process, meaning subpoenas or discovery requests in litigation. But there is this one provision that gives effect to an existing legal requirement that we need to notify people if their personal data, as that term is defined in the statute, is sought by compulsory legal process. And it adds some related rules that other agencies have adopted in their regulations. So if there are any questions and the chair would like me to answer them, I can do so, or I can provide any other explanation that may be helpful.
Commissioner West, please.
Thank you, Randy. This is incredibly well done. I appreciate you taking the statute and implementing it into regulation. Just for my own purposes and to be clear, going through the statute, it mentions the database a number of times. I think it's probably 4 times. Can you go through those times and what each mention requires? Not all 4 times indicate that the database should be public, but I am aware that the provision referencing the health and safety of the officer is a public indication of the database. Is that right?
That's-
Commissioner Wesley, at least I'm hearing quite an echo when you're speaking. I just want to bring that to your attention. I
Thank
think
you.
the thrust of what you were seeking is understood, but excuse me, Randy, please go ahead.
Sure. I have, to the copy I've been using, I added some endnotes in anticipation of questions like this. So the first database is found in section 4H, and that's one that, as I said, the statute does not require to be public. And it provides for a database with records of certified law enforcement officers, including but not limited to this long list. Regarding dates, at which point different actions were taken, both concerning certification and concerning disciplinary action, and the reasons for separation and so forth. But then in section 4J, where it prescribes a public database, it just says the commission shall promulgate regulations for the Division of Police Certification to maintain a publicly available and searchable database containing records for law enforcement officers. In promulgating the regulations, the commission shall consider the health and safety of the officers. So that's why I say it is noteworthy that when it came to the public database, the legislature did not provide the same degree of elaboration and just provided this one guideline about considering officer health and safety. Then moving on to section E section 8E, that is the disciplinary database that the statute does not say needs to be public. And again, it lists a series of forms of information that need to be included regarding complaints, allegations of untruthfulness, failure to follow requirements, various disciplinary actions. And then in section 13A is where we see the public-facing disciplinary database. Again, these regulations would combine the 2 public databases, but this one, it does provide for certain forms of information to be included, but as you can see, the list is not as long as it is in the non-public database. And the regulations do incorporate all these forms of information that need to be included. There's also another place in the statute, I believe it's 8G, where the legislature provided that any decisions, any findings rendered in a disciplinary matter need to be posted on the website. And that's consistent with an existing provision of Chapter 66 applicable to all agencies that provides for essentially significant decisions by an agency to be posted on its website. So I hope that answers that question.
It does. That's very helpful. Thank you.
Are there, yes, Commissioner Bluestone, please.
Yes, thank you, Attorney Ravitz. I think that's an excellent overview, and I just want to make a small point, which is that I think it's clear from the work that you've done that we're recognizing this need for balance. And I would just kind of, from my point of view, point out that independent of any legal consequences, that this is just such a heavy responsibility, because we have a tremendous amount of information, a large database, which has the potential to be harmful, distorted, and misleading. And there's also this issue of scientific integrity and making sure that this database, and any record that we release ensures to the extent possible that, that the data itself is valid and factually accurate and relevant, so that it's not misleading, and that we're sort of being held to an ethical standard as well, just because this is a database, that the information in it, is not misleading in the sense of false positives or false negatives. And it's a tremendous amount of work. So I really recognize that you're working hard under the pressure that we have to release this information, but that's really also an important consideration in my view.
Thank you. Commissioner Calderon?
Yes, thank you. Good morning, everybody. I know we're just looking at the draft. We're not voting on it. I'm sure we're going to have a lot of conversation, but when it comes to the public database, is the commission itself and each officer going to be notified and have the opportunity to review this public information prior to it being live online? Because that's going to be a big ask, I'm sure, of my fellow brothers and sisters that are in the public audience, as well as the members that that we represent in law enforcement. Extremely important, on the same basis as what Commissioner Bluestone is concerned about. Particularly myself, I would like to know if information is going to be shared about Larry Calderon. Is it accurate? Am I going to get to see it before it goes online? And this might be a premature question, but I want to make sure I put it out there right away. And I don't know if anybody can answer that, whether it's Randy or Enrique.
Yeah, let me take the first part, and I'm sure Randy can expound if necessary. But by all means, Commissioner, by all means, we do not intend on making anything public until these regulations are in effect, which will mean you first have to have voted on them and public hearing conducted and comments received, and then a second vote to accept any changes after all those comments. So we are at the very beginning part of that process. As you correctly say, these are important enough. Well, all regulations are important, but this is very much of interest and will take us a couple of times, perhaps more, to come discuss them here, and as necessary until we have balanced those important requirements. There's great public interest in some of this information. There's great need to protect other kinds of information, and there's a little bit of in between that I think is going to be the crux of what you commissioners have to decide and balance. I might note that there's a section in the current regulations that Attorney Ravitz can highlight, but that discusses future guidance or future guidelines that may be developed by the commissioners, by the commission, because we don't really can foresee every instance right now, and we have to allow for the possibility that this will be an ongoing process. But let me also finish this by saying, Commissioner, that from the day that we started to get those disciplinary records, we have gotten a couple of records requests, and we have not shared them because we know that we had to do this balanced approach, including by promulgating regulations that take into account the health and safety of officers, but we also recognize that there's great public interest. People want to know their certification status. There's a presumption of disciplinary matters that have been final to be made public, and we're going to have to again balance all of those important considerations.
I appreciate you answering that thoroughly. It's many answers to many questions, as I know. And there's a tremendous amount of data, which I also recognize that the team is trying to put in, but that's what makes this so worrisome, naturally, to the people that I represent, is that one click of a wrong button sometimes can have something incorrect. So I appreciate you answering it, taking your time. Undoubtedly, we have information requests that are flowing. And of course, as a commission, we want to make sure that we share the information, but let's just make sure that it is in fact accurate and make an effort to make sure that every officer knows what's being posted about him or her before that happens. Thank you. I appreciate that, Mr. Director.
If I may again, Commissioner, you in the report that I mentioned, there has been a little bit of fluidity into those certification categories, for example, because we have gotten some to review some of those records. So we're issuing some correction letters, as I explained. So all of that falls under the rubric of, we're still investigating them. We wouldn't want to make those public right away and find out that we need to make a correction, and then that's potentially, concerning to the person, of course.
Thank you, sir. I appreciate it.
Any additional questions at this time from any of the commissioners? If not, may I ask Randy whether you have any suggestions for my fellow commissioners if they, after their further review and reflection on what you have put forward, is there anything that you would ask us to do before our next meeting, when we would undoubtedly be looking at these again?
It would be helpful if people have thoughts and they could pass those along to me, and I can just act as a central collector of those thoughts. And if people are able to, excuse me, redline the document that was circulated and provide any thoughts of regarding specific language, excuse me, that could be included, that would be even more helpful.
Thank you. And I echo the comment earlier from Commissioner West. This is incredibly thorough, very analytical, and I know that we all appreciate that. We recognize the importance of what is in these draft regulations. Oh, I think there is another question. Commissioner Luma, please.
Just a request. I'm not sure if the copy that we received included those notes that you provided during the session. I'd like to have those if possible.
Sure.
Anything else? Thank you.
If I may suggest, maybe this goes without saying, but questions from commissioners to Randy are also going to be critical, not just comments, because that forces the thinking as to where we may have addressed something or where we may have not. And that's, again, also very much welcome.
Yes, Commissioner Ellison, please.
Yes, thank you, Madam Chair. Enrique, just one quick follow-up on the information that you received, particularly for larger departments such as Boston, that some of the records of officers are kept at the district level, and then some are in their internal affairs. Are we able to make sure that we're capturing both, that we're getting all of the information? That's not used by all departments, but some of the larger departments operate in a different manner. Are we able to get the information about an officer that's reported at the district level, as well as what's being reported to their internal affairs department?
Commissioner, let me qualify my answer that it's mostly, but we deal with so many different agencies that it varies. And let me perhaps clarify whether this is your question, but you may remember we put out a template on that we wanted the disciplinary records to be submitted to us. And this was a fillable spreadsheet, and it was a summary of the disciplinary matter, a historical disciplinary record. Some agencies, especially the large ones, did a download of their internal affairs tool. It's a program, it's a database, and submitted some of that. And there's, of course, this is not something that every agency uses. So others submitted the spreadsheet, submitted information in the spreadsheet. But the majority of all of that information is meant, and was always meant to be a summary of the actual file of everything that goes back and forth in a disciplinary matter. We're not necessarily getting, we never got when it comes to historical records, we didn't get the letters, perhaps, the back and forth that may happen, just the summary. However, that's slightly changing with the new complaints. We are getting submissions that include a lot more detail of the actual record as new complaints and disciplinary matters sort of come in. And we're at the same time building the portal where we want the summary of that information. So that presents a need for us to, which I reported before, to go back and validate a lot of that information that we currently have to make sure that it's uniform and standardized. And that is a fairly, lengthy process, and we're ongoing. That's ongoing, and that's why we're not close to making all of that public. But if we did, it would be all subject to the regulations that we're just discussing and the implications around those. Did I answer your question, Commissioner?
Yeah, you did. I guess for me, it's just the importance of the terms of accuracy, right? If that we're getting an accurate account of the information because it's being kept in two different forms. So thank you.
Yeah, that is critical. There's even a timing element, Commissioner. A complaint comes in and is later found to be unfounded, for example. There's a great, reason to think about whether and when any of that gets publicized, for example, because there's, again, a fair amount of some fluidity that happens with some of these matters. But the regulations anticipate that the earliest of certain criteria, including when the commissioner is when the commission is no longer going to take action on a matter, that then may be disclosed. That's a record such as that may be disclosed. So things like that are very much we're contemplating.
Thank you, sir.
And I think Commissioner Calderon may have a follow-up question.
Thank you. I think, Mr. Director, you might have just answered my same thought. So when we're talking about things that are unfounded, unsustained, that are minor complaints that just come across the desk, like, I don't know, disrespectful treatment. Undoubtedly, somebody gets pulled over by a police officer, depending on their tone of voice, whether it's authoritative commands or maybe there is a disagreement at the motor vehicle window. A complaint comes in like that. I consider that a minor complaint in Boston. Not that I want to be, I don't mean to offend anybody that thinks otherwise in another section, but after 28 years on the job and being from the traffic unit, I can tell you that motorists, including myself, we don't like being pulled over. We want to know what's going on. And sometimes the tone of the officer's voice might be offensive to the motorist himself. However, there is training involved as being authoritative to a certain level to make sure that you are given proper instruction to the person who's been stopped. And it needs to be at a certain tone and level so there's no miscommunication. So, if it's a minor complaint at a district level, that's why departments have rules and regulations to handle those types of complaints from within the district at the district level. So I hope I'm being clear because I'm a little bit confused on both sides. I think what you're saying is unsustained minor complaints are not arising to the commission level in public at that point. Do I understand that correctly or no?
Well, we are capturing some of that data, Commissioner, but the question remains by you all to decide in that particular instance and others, what might be that balance? Is it in the public interest to disclose complaints as soon as they come in or number of complaints? I submit to you that because there's a lot that can change, certainly not right away, but later on that risk may be lessened, and so maybe it's a timing issue. What you correctly point out, Commissioner, unsustained complaints, there's a potential, for example, of creating the wrong impression on somebody that has a number of complaints. Maybe they're the most active in the area where people complain the most, but there's great public interest in seeing if there's trends or there's particular pockets that need to be sort of thought of. You mentioned minor complaints, and this is something that we quickly got from the police world before we even distributed the template to receive the disciplinary records. The association had circulated a template, and they started to submit a lot of these records. Commissioners might remember that we then issued regulations on the complaints that were due to post, and we excluded minor complaints in those regulations. And then some police departments correctly pointed out, I submitted to you complaints that were now in your regulations are minor. Will you purge them? And I said, well, I don't have the authority to purge them, but we don't have yet to disclose them. And this is another instance of where the commissioners may decide, again at a later time, whether and how we deal with these eventualities. There's a there's a balance somewhere, and you will be the ones that decide it.
Okay, yeah, I'm worried right away. I start thinking of a distorted impression that we're given of an officer that might be a very hardworking officer in a particular part. I always use Boston. It's my experience, but you have a particular part of the city that is has a higher crime rate or a higher traffic offense rate, and you have an officer that may receive 2, 3, 4 complaints in a year because certain individuals will know if they file complaints against police officers, even for something as minor as disrespectful treatment, but you have 2, 3, 4 of them in a year, you now start affecting that officer's mental capability as to whether or not he or she wants to go out there and continue stopping motorists. Because every time you write a ticket, you get a complaint, and every time you get a complaint, you have to go through the process of internal affairs and ongoing interviews. And even though that gets not sustained or you get exonerated from such complaint, it's a stigma that's given to the officer, and it affects, I'm well aware of the statute saying the health and safety consideration of the officers on the street. That is a big concern naturally to me. I know we'll probably talk about it a lot, but this false stigma that's given to an officer on minor complaints that might be coming in from certain areas, we may be treating officers unequally. Officers in a hardworking area of the Commonwealth where there's a lot of activity, a lot of crime, may be different than other parts of the Commonwealth where that crime just doesn't exist. So I'm very worried about equal treatment. I'm worried about the mental health and welfare of the officers involved that are in those areas. So something that you'll probably hear me say again as we continue to talk about this, but I appreciate you being thorough in the way that we're doing it. And obviously the team that's putting in the massive amount of data, they get their work cut out for them. So thank you for the time, Commission. I know I'm going on. Thank you.
Thank you. Now, failing to see any other indications of questions, let me move on to the next item on the agenda, which is the joint guidance on Section 12 and use of force. Again, I turn to, initially at least, to our general counsel.
Thank you. You should have before you a statement, excuse me, a statement regarding the Section 12, excuse me. I'm just calling it up right now, regarding a joint post-commission and MPTC guidance as to General Laws, Chapter 123, Section 12, and the use of force. And this is something that was addressed previously by Commissioner Bluestone, and I will give her the opportunity to speak to it if she wishes to do so, and if not, then I can address it.
Thank you, Attorney Ravitz. I think that I'd like you to cover the statement, but I just would like to say, as I have in the past, that that this particular issue around the Section 12A has come up many times in conversations that I've had with law enforcement officers across the Commonwealth. And I think it represents a kind of a unique area for them. It is inherently challenging because the 12A by definition involves involuntarily transporting an individual who's believed to be mentally ill and at risk of harm to themselves or others. And that is obviously in many cases against their will. And these can be sometimes very complicated interventions for law enforcement officers as well as EMTs and families who are involved. So, I just, I obviously feel very strongly about this particular issue and think that this is a place where partnerships among mental health professionals and first responders are critical. And that it's also a place where there's not always agreement, which is why the mental health professional has been placed, by law in the position of having the authority to make the determination because they have available to them usually the most extensive information about a person's factors. So I think with that, I think you've drafted a really nice statement that I personally have read and support.
Thank you. I will share, share this on the screen. This statement begins by laying out the relevant provisions of Section 12. And essentially it summarizes those provisions that allow for a law enforcement officer to restrain someone and affect the transportation of that person to a facility for hospitalization when it has been found that that the person is in need of hospitalization. Again, because of a likelihood of serious harm by reason of mental illness. And when the Post Commission and the MPTC promulgated regulations regarding the use of force, there were questions raised from members of the law enforcement community about whether there is a tension between the restrictions on the use of force and the provisions of Section 12. And essentially, this statement provides a way for the Commission and the MPTC to answer that question in the negative, that there really is no tension between those two. And that's inherent in some of the provisions of the use of force regulations, but this provides additional clarification and certainty. And what it says is that, towards the bottom, that officers are not prohibited from using necessary and proportionate force when de-escalation tactics have been attempted or failed or are not feasible based on the totality of the circumstances in a Section 12 situation, and that they are not relieved of the duty that they have to take certain steps to affect a hospitalization. And that when a determination has been made by a licensed mental health professional that pursuant to the statute that I mentioned earlier, that the officers should not substitute their own judgment for that, but should take the action that's called for under Section 12, and that they would not be in violation of the use of force regulations where they use non-deadly force that's deemed to be necessary and appropriate, proportionate to gain control over someone and overcome any resistance, excuse me, to affect their duty under Section 12. So if there are questions about that, we can answer them if the chair would like.
Do any of the, yes, Commissioner Wynn, please.
Randy, thanks for your work on this, and I think it's going to be helpful, particularly for the officers that I received questions with. But I do have one outstanding issue, and I'd rather we don't have to go through this twice. So at the bottom, in the part of the response, it talks about use of force in general. So we're talking about officers from using necessary and proportionate force when de-escalation tactics have been attempted and failed. They're not feasible based on the totality of circumstances. And that's the language from our regulation. But in the conclusion, it only addresses non-deadly force. And the reality is I'm dealing with a situation right now where during a crisis, the subject armed themselves, and my officers then were compelled to use deadly force. I think this should be more encompassing because I don't want us to have to revisit this.
Okay. I think the intent was not to change anything regarding the use of deadly force. It just doesn't comment on that one way or another, so that the regulations would govern. But if there's language that that you, Commissioner, or anyone else thinks would be helpful to add, we could.
I don't know that the word non-deadly is necessary in the conclusion. We're talking about use of force.
There's others who've raised their hand. Randy.
Okay.
Uh,
I don't think that would be inconsistent with anything, with either the regulations or Section 12, but I wanted to give other people an opportunity to comment on that.
Commissioner Calderon, please.
Thank you. Commissioner Bluestone, thanks for putting this down again. I know we talked about it in the last meeting as well. I share the same concerns that the chief is talking about, because right away I start thinking it says that we're not relieved of duty to hospitalize an EDP under Section 12. So right away I think of, okay, are we going to provide further training for the officers on what we're supposed to do? Because using the word non-deadly seems like you can't do anything above. So I'm worried about it, and I'm trying to recollect on what the Boston Police Department sent out right away after our piece of legislation was put in place, that the Boston Police Department effectively does something totally different as far as making the determinations on a Section 12 of not going in, of not physically restraining somebody. So I will get that paperwork and share it with the commission and Randy, the executive director, everybody on our side. But I'm really concerned about how we instruct the rank and file officers that are actually on the street. How do we instruct them on what they can and cannot do? Because it doesn't seem clear to the men and women that I work with and that I represent. There's a lot of posturing going on. And at the end of the day, God forbid someone uses deadly force, that there's going to be questions that need to be answered. And we need to make sure that we're effectively training and protecting the men and women on the street that are out there doing this job.
I know we have other commissioners with questions. I think Commissioner Bluestone and then Commissioner Kezerossian.
Sure. I just would, I concur with what Commissioner Calderon and Wynn are saying. I think that this is a complex issue because when these situations develop, they can escalate and they can become very dangerous for law enforcement officers. And I think that the use of force regulations already provide directives around how an officer should make the determination in their response. I think what complicates this particular issue is that they're called into situations sometimes where the person who is deemed to have a mental illness may be presenting only at risk of harm to themselves and not to others. And then when officers get involved in the situation, it can escalate. But I do agree that, officers, if they are being asked to intervene in these situations, need to have the flexibility to make a judgment call about their response that isn't restricted, and to follow the use of force regulations as we've written them.
Commissioner, thank you. Commissioner Bluestone, Commissioner Calderon, and I think I saw another hand as well. Commissioner Keserosian, please.
Yeah, I agree with the concerns as well, and I think the way Commissioner Bluestone summed it up sort of is encompassing what I'm going to say. And I thought maybe if there's a way to work in here that they may use such a force as per the post commission, the regulations on use of force, and refer back to that might give a little more guidance, because it does address force that can be used under certain circumstances. And I think that I do have to agree that putting non-deadly in here could, and no pun intended, handcuff a lot of situations that you may need to have a little more flexibility for whatever the situation may arise. But if you then refer to the use of force regulations, you've got a good set of guidelines and regulations as to how you can and can't proceed under certain circumstances when things escalate.
Thank you. Commissioner West.
Thank you. I agree there can be some confusion. I think Randy said it earlier. If we just got rid of the word in the last paragraph of non-deadly, and Randy, I don't know if you can put that up again, and it just said force, then comma, pursuant to the regulations, comma, then we're sending them right back to the statute, which is where they should start.
Commissioner Luma.
I just wanted to, I guess I really am just wanting to highlight what Commissioner Calderon said in regards to kind of the complexities around training and understand what the needs are around this, given what the statement is. So I'm just wanted to reiterate what he said in regards to wanting some of that documented clarity. And I'm wondering, I know that you're going to be, Commissioner Calderon, you're going to be providing information in regards to Boston, but I'm wondering, should we consider what other agencies are doing in regards to that aspect as well? And I'm not sure how we obtain that information.
Commissioner Calderon.
Just to answer the commissioner, I can address the organizations that are part of the Massachusetts Law Enforcement Policy Group, which has a very overwhelming majority of law enforcement organizations attached to it. I'll send an email out and ask them if they could forward to me any department policies they have. Surely the chief could do that with the chiefs associations as well, and we can get them to the commission. So I'll do that after we conclude today.
So are we in a position then, fellow commissioners, where we will gather additional information and not take any vote today, but be prepared to deal with the additional information and a modified form of the joint guidance at our next meeting? Seems to me that that makes sense, given the nature of the questions and the comments that we've received. Is there anybody who disagrees with that approach? And therefore, we will plan to do that. Again, thank you very much to those of you, particularly our general counsel and Commissioner Bluestone, who have worked on this guidance and working with the MPTC on this. We're grateful for that. I think the issues that have been raised today are significant issues that require additional reflection and comment before we take the commission vote on this guidance. And I think with that, unless there is any other matter, any questions that anybody has, I do not know of anything that was not anticipated by me at the time of posting that has occurred. And I would therefore now entertain a motion to adjourn. Is there such a motion?
So move.
And
I'll second it.
thank you. May I again just thank all of the commissioners and the staff and those who have worked with the commission on all of the work that has been done since our last meeting and before. I think we are all incredibly in awe and impressed with all that has been accomplished thus far. We recognize how much more needs to be done, and we are grateful for the opportunity to work with the staff and with each other. I think with that, Commissioner Bluestone, do you, your vote on the motion to adjourn?
I approve.
Commissioner Calderon,
I approve, yes.
Commissioner Ellison,
Yes.
Commissioner Kasserosian,
Yes.
Commissioner Luma,
Yes.
Commissioner West,
Yes.
Commissioner Wynn,
Yes.
and I also approve. Everyone have a good remainder of summer. And thank you very much again. Goodbye for now.
Thank you.